Security deposits are often a problem tenants have. Landlords get someone's security deposit and they have no intention of really returning it. They cash those checks, they put them in their checking accounts, they spend the money on anything they want to, and then when a tenant moves out, they have the gall to ask for it back? No. Landlords often have no interest in returning it because they've spent the money and they don't want to give it to you. They don't have to escrow it in Texas. In other words, they don't have to keep those funds separate. They can use it however they want. So that's what landlords do. And they have a direct incentive not to give it to you because it's money they think out of their pocket. Now, how do you get one back? Well, first of all, recognize this. You are not entitled to get your security deposit back until after you move out. In other words, you can't just ask for it in advance, and you're not allowed to use it as your last month's rent. That can also get you in trouble. So the best plan is to clean up your apartment or house and ask the landlord to walk through the residence with you to see if they spot any deductions, any problems, because you ought to have a chance to fix those first and see if you can avoid them deducting things from your deposit. One thing, though, a tenant needs to make sure of is that they've given the landlord the forwarding address. A landlord has no duty to return a deposit or give you an itemized list of deductions unless they have an address where to send it. Now, you shouldn't necessarily send or give the landlord a forwarding address that's out of town or out of the state or out of the country. It'd be best if you gave an address, a post office address, or a friend that's in the local area, because landlords sometimes feel like you will never take action against them if you've left the state, for example. So if you have a friend that you trust with your money and your mail, that might be preferable. But if you don't have those options, provide them your new address, and that's where the landlord needs to send either the deductions list or the money or a combination of the two. Now, after you go ahead and move out, the landlord has up to 30 days to decide what damages have been caused by you and make any deductions they feel appropriate. So you have to wait at least 2 or 3 weeks. Now, after 30 days, a landlord can be held in violation of the law, and if a judge were to find that the landlord acted in bad faith, then the landlord could be responsible for triple the amount of the deposit they've held improperly. So you have to wait a little while, but if the landlord waits too long, they can end up owing you even more money than you originally gave them. One of the bigger problems is the deductions themselves. A landlord gets sometimes very creative on what they're going to make deductions for. Can they deduct for a light bulb? Can they deduct for some sort of cleaning or scratches or stains on the carpet? It depends. Each case is different, and it's very difficult to give, in general what the rules are, but I can give you one standard, and that is a landlord is not allowed to deduct for things that are caused by normal wear and tear of the property. So obviously a few nail holes there and there, or a few scratches there and there, or a few marks on the carpet here and there might probably be considered normal wear and tear. Deep stains, massive scratches, huge holes in the wall probably wouldn't be. So that's often where the disputes arise, is what kind of deductions a landlord has made. But again, the landlord has to make those deductions and give you an itemized list of those deductions in writing within that 30-day period. If, again, a landlord's held in bad faith, they're not allowed to make any deductions whatsoever. So if they start deducting for everything that's improper, a judge very well may say you're acted in bad faith and triple the amount of the deposit and award that to a tenant. You should send a demand letter to a landlord first before filing suit in justice court. It's better to send a letter and explain your position and ask for them to respond and see if you can get it worked out. Because even suing in justice court takes some time. It takes some risk on your part, and you have to pay some money unless you're low income, in which case you could file suit with something called an affidavit of inability to pay cost. But either way, it's best to work out these problems without having to file suit in court.